Of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Please be seated. Good morning. Ask Mr. Doug Schema to please, the clerk of the Kansas Appellate Court, to please call the 10:30 docket.
Thank you, Your Honor. The first case on the 10:30 a.m. docket for Wednesday, October 26, 2022 is appeal number 123005. State of Kansas versus Edroy D. Taylor Jr., Shawnee County, briefs both sides.
May it please the court, Caroline Zuschek, Deputy Capital Appellate Defender, appearing on behalf of Mr. Edroy Taylor. If I may, I'd like to reserve 3 minutes for rebuttal.
3 minutes is reserved. Thank you.
Thank you.
It please the court, Your Honors. Assistant Solicitor General Michael Sarah appearing for the state appellee in this matter, present, ready for argument.
Second case is appeal number 118310 in the matter of Curtis N. Holmes, original action and attorney discipline, reinstatement petition.
Justice, and may it please the court. I'm Curtis Holmes. I'm appearing pro se. I'm present and ready for argument. I would ask for 5 minutes for rebuttal.
Good morning, Madam Chief Justice, Justices. My name is Julia Hart. I'm a Deputy Disciplinary Administrator and appear on behalf of the Office of the Disciplinary Administrator. And I'm present and ready for argument.
Thank you.
Your Honor, that concludes the docket for the week of October 24th, 2022.
All right. Thank you to all counsel and Mr. Schema. Now I will call forward the attorneys in 123005 Kansas versus Taylor. You're settled and ready. You can may approach and begin.
May it please the court, Caroline Zuschek, Deputy Capital Appellate Defender, appearing on behalf of Mr. Edroy Taylor. A brief synopsis of how we ended up here today. Mr. Taylor was convicted of aggravated vehicular burglary and sentenced to 100 months prison and ordered to pay $1,954.36 in restitution at a rate of $15 per month to begin immediately while incarcerated. The sole issue on appeal is whether the method of repayment of $15 a month to begin immediately during incarceration is workable. The district.
Counsel, can I back you up just a little bit?
Certainly.
Do you agree that the burden of proof to prove unworkability was on your client?
Yes, absolutely. And that was one of the reasons the Court of Appeals affirmed the district court's decision imposing the $15 a month. It's our position that Mr. Taylor did prove unworkability. He, in response to questioning by the court, noted he had no car, no home, no assets, and he had some support obligations for minor children, though based on the answers in the record, it appears it wasn't an official child support order. And he was immediately going to begin incarceration.
What's your position concerning whether the district court can consider your client's unsworn statements at hearing, and whether or not it can be considered as evidence?
Yes, and yes. First, the district court considers unsworn statements by the clients all the time. In fact, some of these statements were solicited by the court to determine whether it would be appropriate to impose costs and fees. And if the judge can consider it for that purpose, where the statute requires the court to take into consideration those things.
Didn't that
It-
even happen in this case, that the district court made an inquiry about attorney's fees and costs and made a determination?
Yeah, at the original sentencing hearing, the judge asked Mr. Taylor, like, what are your assets? And he basically gave a few answers.
And was that in the form of unsworn testimony? I mean, it was.
He was not sworn.
An interaction from the district court to where
Right,
defendant would.
there was, yeah,
defendant.
he wasn't on the stand. It was just an sort of off the cuff discussion, which,
And is that the same thing that happened in the restitution determination? Also, the inquiry was made from the bench to your
Yes,
client?
that's my
sitting at
understanding.
Defendant's table, okay.
Yes. And it's typically how those things are done. I don't think I've ever seen the court swear in an accused before determining costs and fees or attorney's fees. The court asks from the bench, and the presumption, of course, is that the person is going to reply truthfully. And I've never seen the state argue that that wasn't sufficient evidence to support a determination of costs and fees or attorney's fees. And so if it can be considered for that purpose, I find it hard to believe it couldn't be considered for this very parallel, similar purpose.
Well, the Court of Appeals said it really can't. So what is your authority to say it can and should be?
Well, the authority would just be that it is considered in similar situations. I don't think there's a case on point that says it can be. I don't think that there's a case that says it absolutely can't be. Obviously, the better practice probably would have been to swear him in, but I think we're talking about a technicality when that evidence is being considered in the same case for other determinations which require an evidentiary basis.
Clearly, he has a statutory basis to allocution.
Right.
So is there a difference?
I'm not sure. Like,
Well, is there a difference between the legality of the sentence and whether or not it should be imposed, which is clearly set out in the allocution statute, and those things that he testified to about restitution? Or is it all considered something that falls within the allocution statute?
I would argue it all falls within the allocution statute because part of the sentence is the restitution, as well as costs and fees, and the court has the authority to allocate that. And based on the answers to the questions, it's obvious that Mr. Taylor did not have sufficient resources to pay even the de minimis $15 a month. And in fact, this court can take judicial notice of the fact that he was sentenced on June 10th, 2020, and the motion to reconsider was June 11th of 2020 during the middle of the pandemic. And in fact, work was not happening in the county jail and in some prison facilities as well. So he indeed was not able to begin to make any sort of payments, and the plan ordered by the district court set him up for failure from the get-go.
Could you tell me your strongest argument as to what the evidence was about his ability to pay day after sentencing in the future? What he would have in the future, what he would be able to make in the future while he was incarcerated?
The strongest evidence would probably be the IMPPs that were cited in the record on appeal, and which are common knowledge to, I would assume, most district court judges, which is that the average wage per day is 45 cents to $1.05.
Was that presented to the district court?
It was not.
So it's not part of the record before the district court.
It was not part of the record before the district court, but I would argue that it's common knowledge. And it's also something, I mean, it's the policies and laws of the state. I can't imagine that district court judges sending as many people as they do into custody aren't aware of the limited financial opportunities defendants have while incarcerated.
Was the judge requested to take judicial notice of that common knowledge?
It wasn't, but it doesn't have to be requested. The court may, under I'm sorry, let me pull up the rest of the judicial notice statute, which is sorry, 6409B, it may be taken without request of the party. If it's the duly published regulations of government subdivisions or agencies of this state. We would argue this is a duly published regulation of the Department of Corrections. Obviously, it's not the KAR, but it is of indisputable accuracy. It's readily available, and there's really no dispute that that's what the daily wages are.
Practically speaking, what happens to your client if he does not pay $15 a month?
Well, it's, I would assume, already been sent to collections because we know that he couldn't make the payments.
And then what happens?
A 33% surcharge is added on to the total. And then it's not very clear right now what happens. Previously, it used to be converted to a civil judgment. Under the revised restitution statutes, it appears it can still be garnished from any paycheck or wages. And
How can it be I mean, is there a statute that says it?
yes. I cited this in a brief I just submitted. It's, I want to say like 161, 69. It's the
Even though
first-
it's not a civil judgment?
Even though it's not a civil judgment, it can still be garnished.
And where does the 33% surcharge come from?
It comes from the fact that it's automatically referred to a collections agent within 60 days of non-payment, and the collection agent is authorized to collect up to a 33%.
And that's through
surcharge.
the district, like the contract that the district court has with who's
Yes.
it's the court that's the entity doing the collecting. I mean, even though it's contracted out,
Yes,
or is it DOC? Like who does that?
it is the court.
Okay.
Or the victim or an aggrieved party can also use the same collecting agents, but typically the court is the one who automatically refers it after 60 days. And I can provide those statutes in a 609 letter following argument. I should know them off the top of my head, but I can't remember the numbers. But yes, that is the process, and that is what happens after the amendments. So he was set up to fail here. Even though $15 a month sounds like a de minimis amount, it wasn't de minimis to him. There was another case at the Court of Appeals recently. Another panel decided the district court ordered another client of mine to pay $200 a month while incarcerated, and the Court of Appeals found that was obviously unworkable. The evidence about the IMPP was likewise presented for the first time on appeal, and the court took notice of it. And they noted that the problem wasn't that the 33% collection fee attaches, it's that it attaches without any opportunity for success. You can't get blood from a turnip, and in this case, Mr. Taylor's financial situation is a turnip. And for those reasons, we would ask this court to vacate the restitution order and remand it with directions to begin restitution repayment either at a lower amount per month or upon his release from custody. And again, he's not contesting the total amount. He's happy to pay that. It's just the monthly payments are presently unworkable. And if this court has no further questions, I'll reserve the remainder of my time for rebuttal. Thank you so much.
It pleases the court, Assistant Solicitor General Michael Sarah appearing on behalf of the state of Pele in this matter. Your Honor, it is the state's position that the burden of proof, as Justice Wilson's inquiry stated, to establish unworkability of a restitution plan or restitution in and of itself is on the movement.
So what should have happened here? I mean,
Evidence.
the district court clearly has evidence before he or she, I'm not sure who.
It was Judge Geyer.
Judge Geyer, that this individual is destitute. There's no money available to him, no resources. The state even suggests, well, he can go ask his friends to pay it, which I don't see why that is even a consideration. But it's clear before the court that he's impoverished, no money's available, and that there's no evidence that he can make money while he's in prison. And if he does, it's going to probably exceed the $15 that's due. Why isn't that enough
Your Honor, I would
to
dis-
show that the burden has been met and he's shown they waived attorney's fees and costs? That takes generally a consideration on the ability to pay. Why isn't what's before the court is demonstrated here?
Your Honor, I would disagree that evidence was presented. There were some unsworn statements of the defendant made.
I understand.
Yeah.
So an inquiry like you and I are having, I don't gain any knowledge based upon that.
I think there's a difference in gaining knowledge and admitting evidence. I think the difference here is that the restitution statute, if you are claiming to be under the exception that either I don't owe or I can't pay, requires production of evidence. Statements to the court that are unsworn, this court has previously found in Holt, are not sufficient to establish that burden. I'm not.
So the rule is now that in any restitution hearing, if someone is claiming indigency and inability to pay, they have to get on the stand and prove that.
I think that they at least have to take the stand and give a sworn statement or provide an affidavit that is sworn. That is my read of the case law, yes.
Mr. Sarah, just to, not to interrupt you again,
Oh.
but I think everybody agrees the defendant has the burden to show it's unworkable. And in this case, he's proved, at the hearing, I'm currently broke. Would you agree with that? Currently.
Currently. Based
Okay,
on-
it did without the issue about,
No, and
Yeah.
I base that, he actually didn't say anything in response to the court's question about restitution. His attorney did. And I would agree, she represented to the court that he had no money and no liquid assets at that point.
okay. And the district court says you're broke now, but perhaps you could make money or in prison or borrow money. Okay. Okay. So from your family or your friends, not borrow, but you could get money from your family or
That may
friends.
be a potential source of money, yes.
Right. Okay. So why isn't that pure speculation by the court? Why hasn't the defendant met the burden to show that he's broke and that nothing is going to change between today and tomorrow because he, I just wrote, is it defendant's burden to respond to speculation by the court that he could make money in prison? Is he required to call an expert to testify as to whether a prisoner will secure employment? And if they do, how much money that prisoner will make?
Your Honor, part of the thing that I don't think the court is speculating on is, again, the defendant didn't produce any evidence below about his future earning potential.
But how is he supposed to do that?
Well, he does have the ability to work in prison and he chose not to present that evidence.
How do you know that? How do you know
I
when
have
it's
that
ability?
as the defendant has put, as the defense counsel has pointed out, that is my common knowledge and my previous experience as a trial attorney. I can
So
only
you're
assume-
saying
I
that,
can only assume Judge Geyer knew that too, and it was suggested by the state in one of the motions that he had this
but
earnings
what's
potential.
that speculation? There are prisoners that can't work or that don't get a job, especially in the middle of a pandemic. So as Ms. Zeschek pointed out, he's ordered on June 10th to start paying immediately. June 11th through, I don't even know, maybe a year. I can't remember, exactly, but he's in county jail because they're not even sending people to prison. So clearly for that first whatever, he's not working because he's in the county jail and he doesn't have a job.
Again, all information I think should have been presented below. And was
How
not.
is he supposed to know he's not going to prison, that he's going to be kept in the jail?
He has the burden of proof to establish he is the exception to the rule, Your Honor. That is
But
where,
he doesn't know what's going to happen to him. He is not in charge of his life.
again, Your Honor, this would have been information that he should have presented to the court. The only thing that he presented to the court was, I have no money at this point and I'm going to prison.
And I have no idea what's going to happen to me
No.
starting tomorrow because I'm not in control of my life.
I actually never said that, Your Honor. He said there was never any statement by the defendant or counsel about, I don't know what's going to happen to me while I'm in
So
prison.
what would have satisfied under the burden shifting or the burden to prove unworkable? What evidence should he have presented?
He needed to present sufficient evidence of compelling circumstances to excuse requirement to pay restitution.
Give me an example
An example of what, Your Honor?
of unworkability in the future, because you
Unworkab-
already agreed that he already proved.
If
that he's
he,
currently
and
broke.
now I'm speculating, Your Honor, but possibilities would be if he had a physical infirmity, a mental infirmity, if, as you put it, if the pandemic had some effect on the workforce in the prison, something to indicate, and we've in previous, I'm sorry, Your Honor.
I don't know how he's supposed to know that on the day of his sentencing.
He's asking to be excused to pay $2,000, Your Honor. I think that it is on, the statute is very
No,
clear.
he's
that
not asking to be, no.
He was being asked to excuse, do not have to pay that immediately. That was his request. Actually, his request at sentencing said restitution was completely unworkable at all. Didn't mention the payment plan. In his amended motion, he said, I'm willing to pay it, but please give me till the end of my sentence. So there are differing requests made at sentencing and the motion to amend.
But based on the evidence presented, don't you think it would have been much better if the court would have said this restitution order is made contingent upon employment in prison?
That is possible, and there's previous cases where that has happened, Your Honor, and it's been appealed, and I can't remember if it was upheld or not. I'll be honest, most of our case law dealing with this issue usually has to do with, and the Holt case is a good example of restitution being ordered upon release. And there, they do say the defendant has the burden to come forward. If you don't want to pay it upon release, or if you want to be excused due to your financial circumstances, and Holt was a life sentence with a possibility of parole after a hard 25, I believe, that he had to come forward with evidence. And this court said at the sentencing hearing to show why he shouldn't have to pay when he's released. It said his unsworn statements that he was currently broke and couldn't predict the future was not enough.
But
I
the
believe-
law has changed since then, and that's not this case.
How so, Your Honor? To my view of the restitution statute, the unworkability provisions of the restitution act.
Right, I mean, that's true, but now you got to pay right away.
Not necessarily. I believe the statute currently says you get to either pay it immediately or upon order of the court. And if it is, and again, the order of the court to pay upon release, that's not necessarily even binding on the parole board when somebody's released on post release.
Exactly.
That's the Eubanks case, says that it's a suggestion. And interestingly, the burden when they get out on post release is the same here on workability. They still have, if they want to establish unworkability to be excused and paying restitution or at a reduced rate, they have to establish that to the parole board.
What's our standard of review here? Is it a negative factual finding essentially that there was not, or there was an absence of a finding of a compelling circumstance?
Abuse of discretion, Your Honor. That is, that no reasonable person would have taken the position by the district court, mistake of law or mistake of fact.
And then, okay, under the abuse of discretion standard, how do we evaluate the absence of a finding? Just essentially still abuse of discretion, or is there any guidance beyond that that directs our review?
Not a ton, Your Honor, at least from my review of it. Essentially, the burden of proof placed on a defendant in this kind of situation being when he is asking to be excused from paying or paying at a reduced rate is to prove a negative.
And the district court in its ruling addresses the arguments that were raised by the defendant in terms of the workability. Is that correct?
It is, Your Honor.
Is
And indigency, yes, sir. In the written order issued by Judge Geyer, he said that he considered the current status of the defendant as an indigent person, also taking into account his future ability to pay, and said there was nothing in the record to indicate that he would not be able to earn a limited income while in prison.
So are you talking about, counsel, then that it would be up to the defendant who knows the defendant's situation, future situation, to address the court or bring testimony from witnesses or documents that say, for example, I do not expect to inherit anything while I'm in prison. I don't expect to be able to, this is proof of how much people can earn in prison. Other people have earned in prison, and those kinds of things. Are those the things that he has to bring forward?
I believe that is the state of our current case law, yes, Your Honor. The Heron case, which is cited by the defendant in his brief and relied upon, where unworkability was found, there was extensive testimony presented about the financial burdens placed on the defendant in that case, which would have been prohibitive to her paying restitution, particularly in the amount ordered, as I recall. Every case I found where unworkability has been determined, there has always been evidence by way of what's either testimony from other witnesses or by the defendant themselves.
You mentioned that he had children. One possible piece of evidence might be a court order for child support, future child support, correct?
Yes, Your Honor. That honestly, had I been defense counsel, I may have presented that as if I was trying to get a restitution excuse.
Well, aside from that, he did say that he had children.
He said he had children. He said he pays their mother to take care of them. But then also when Judge Geyer asked, again, this was on the attorney's fees issue, If he paid to support them, he advised, no, he did not.
So we know that he's indigent today. We know that he has children. Can we use that statement as something for the court to consider as evidence, as a legal obligation for him in the future during his incarceration?
If it had been presented as evidence, possibly.
Well, he said it.
And Your Honor, my read of our case law on this particular issue and his burden of proof doesn't, simply saying it and not being sworn to it is insufficient as evidence.
So does the answer then turn on that?
I believe it does, Your Honor.
So we're gonna make them file an ineffective assistance of counsel claim, so it can come back up on that?
Well, Your Honor, my primary practice is ineffective assistance of counsel, and I'd say I've seen them filed for far less. And honestly, if evidence is required to be presented by statute, I think that is the obligation if you're asking to be excused. Now, whether counsel is ineffective or not in this particular situation, that's a matter for a different kind of post-conviction proceeding.
But he's
Yeah.
statutorily able to allocute
Yes, Your Honor.
as to the legality of a sentence. So at what point do his statements in this case to the judge depart from what he's statutorily entitled to do without being sworn? What requires, in your mind, cross-examination, being sworn and subject to cross-examination?
Your Honor, the allocution, the difference I see here is the allocution statute being allowing you to advise the court and address the court about your sentence and the legality thereof. The restitution and the workability provision don't have anything to do with the legality of the sentence. It's being asked, you're being asked to be excused from or pay at a reduced rate of a financial obligation incurred as a result of your conviction. So the argument, when you're asking, my difference is when you're allocating and talking about the sentence, when you're talking about workability is just asking for an excuse, some mercy based on a financial or other situation where you have evidence to support that, versus allocution where you are able to address the court, advise the court of your thoughts and feelings and requests for.
And ask the court for mercy
Ask the court for mercy, yes.
in allocation?
Yeah.
Allocution? Sorry. So you're in allocution when you're talking about the time of your sentence or, it within the border, within the box, going for the lower number. What's the difference between that and pleading for mercy and restitution and pleading for mercy?
I believe because this court has said restitution is the rule and unworkability is the exception, and evidence is required by statute to invoke the exception. Whereas requesting mercy through allocution or low box number, or, if you filed a motion for dispositional and or durational departure is fine. And I will say I've had clients that when I was a defense lawyer did testify at departure hearings.
Okay, what you're saying that restitution to depart from the presumption of restitution, you have to have evidence.
That would be one way to put it. Yes, Your Honor.
And is that a statute you're talking about?
Yes, the restitution statute and the case law requires the burden of proof to produce evidence of unworkability on the defendant requesting to be excused.
Counsel,
Yes, sir.
I'd like to spend at least a minute or two.
Like I don't want to eat into Mrs. Usek's time, Your Honor. And
I'll eat into it. I want to spend a minute or two setting aside the substantive legal questions about burden of proof and what counts as evidence and all of that. And just ask some practical questions.
Yes, Your Honor.
What happens if this $15 a month is not paid?
Your Honor, I am not as familiar with the civil garnishment provisions.
Do you dispute that this will go to collections and
I'm not.
interest and fees will be added on top of it?
That I'm not certain of.
So
In
when
light of the
Sorry, go ahead.
statute continues to say chapter 60, article 7 can be used to collect. And I will tell you, Your Honor, I'm getting notices on former cases where it is being used to garnish wages. I don't know if there are fees attached to that. I would assume there are, but I don't know that there are. And in wake of Robinson and the unconstitutionality findings, I'm not sure how the civil code continues to interact with the restitution statute, but that is how it is being litigated.
So when the defendant in this case filed his motion for a modification the day after
Yes, sir.
sentencing, the state filed a response, I think, is that correct? And I look at the district judge's ruling and I see the district judge talk about the state's objection to jurisdiction.
Yes, Your Honor.
But I don't see, or at least I haven't dug into the case enough, the record enough to know what the state's position was on the request to reduce restitution. Did the state take a position?
The state objected to the reduction, advised that their position was that the defendant had not produced evidence
Okay,
that his future income.
so this goes to my whole practical line of question.
Yes, sir.
And I'm reminded a little bit of the viral Allen Iverson clip about practice. We're here about $15,
Yes, sir.
$15 a month. The state has insisted that this $15 needs to be paid.
Yes, sir.
We've had all of this time and judicial resources taken up over $15 a month. We're talking about collection and fees and interest being put on top of this individual after when he's in jail. I just, is there a practical explanation for why the state over $15 a month?
As Your Honor, I'm sure is aware, this is case by case. And in this situation, someone who was badly hurt, $2,000 in medical bills, there was a victim in this case. And the purpose of restitution by our case law is to not only rehabilitate the offender through payment of restitution, but to compensate the victim.
So is it fair to say that the state's position is that if we don't get this $15 a month, we won't get paid at all? I mean, because I will say I have some skepticism about that argument, but at least that would make sense to me.
I would doubt that would be the case. Your
Okay,
Honor.
so if that's not the case, then doesn't the whole, and I get that crimes have real, I mean, obviously have significant impact on victims, and restitution is a good and appropriate thing as set forth by our legislature. That all makes perfect sense. But what we're talking about here is the $15 a month while he's incarcerated.
Yes, Your Honor.
Not the payment of restitution. So if you're conceding that, you know, you're not saying that, hey, if we don't get this $15 starting right now, then the victim's never going to see any money.
I'm not conceding that, Your Honor, because
Oh, I thought you just did.
Standridge and I were having a lively discussion. I can't predict the future. I'm speculating on that as well. So no, I will not concede that we'll never see that money. We may never. Mr. Taylor, when he's released, may never work by choice or whatever.
Well, let me put it a different way. Even if it's just purely a matter of tactics, it would strike me as more likely. I mean, if my goal is to get the most money out of this individual I can, would strike me as a better strategy to wait until he's out of prison and can work and then go after him.
And Your Honor, I will say this, in the cases where where unworkability based on payment in prison in our previous case law has been found, that has been the court's ruling. They vacate the payment plan, uphold the restitution, advise that the court's order that restitution be paid.
And that may not be available to us based on the legal precedents and statutes. And I get that. I'm just trying to, again, I think these cases have a really significant practical dimension to them. And if everyone's goal is to get the victim made whole, I'm struggling to see how this is the best way to do it.
Well, I think there were two things. One of the things Judge Geyer put in his order and that the Court of Appeals noted, and I think their analysis is very apt. The offender reformation portion of the restitution, encouraging Mr. Taylor to work while in prison because that promotes offender reformation, provides him with skills, provides him with tools when he gets out. I think that's one component. The other is, Judge, or Your Honor, the fairness to the victim. How long should they have to wait before they receive compensation? 100 months, a life sentence? What is fair to them? Because there are balancing interests here. I think the state's position is it was not unfair to ask Mr. Taylor to pay $15 a month on a $2,000 medical bill on harm that he caused. Now, I don't think it's unfair. I think that's more than fair to the victim. The practical effect, I recognize, but practical effect sometimes has to give way to fairness to the victim and justice being done. Restitution is something that is required as a result of a conviction of this kind. I am well over time, Your Honors, unless someone has additional questions for me.
I guess I have one.
Yes, sir.
Wouldn't you agree the Court of Appeals overstated notion that unsworn testimony has no value during these hearings? Holt.
I don't know that they overstated it, Your Honor. I think they very strongly adhered to that precedent.
What they say is the Supreme Court in Holt, and I wrote Holt, held that because the defendant was not sworn as a witness, his so-called testimony about his financial statement. There was no holding that way. It was an observation on the way to a different point.
In which case, Your Honor, if there's dictum or in that case, it's unclear, I think that it should be cleared up. Because I tended to read Holt the same way this, the Court of Appeals did, and the precedent of this court is that if you want it to be considered as evidence and it is your burden of proof, you should be sworn and subject to cross-examination.
I think what it says is the defendant was overstating as testimony something that wasn't testimony. It doesn't say that you don't get to have these what are amount to very practical exchanges between parties during litigation with court. So
I'd agree, Your Honor, but I also think that in this particular situation where there is an evidentiary burden on the movement, that it's not unreasonable to request that they're going to present evidence that it be sworn.
Would also be reasonable to say perhaps the weight and credit given to what he says might be a little different without cross-examination than it would be with cross-examination.
I would agree with that, Your Honor.
Questions? Thank you, Mr.
Thank you, Your
Sarah.
Honor.
Reserve 2 minutes. I'm sorry, you reserved 3 minutes. I looked at the wrong place on my sheet.
Thank you, and may it please the court. To start out with, opposing counsel noted that there's an evidentiary burden on the accused to come forward with evidence of unworkability. And he characterized that burden as statutory. I acknowledge that the case law says that the burden to prove unworkability is on the accused. However, the statute 6604B1 doesn't say that the burden is on the accused. That's case law. And it also doesn't say that evidence is required to be presented. It merely says that the court, if it finds compelling circumstances, can depart from the order. So if we're looking at what the statute actually requires, I believe that what occurred in this case should be sufficient. There was a back and forth between the court and the accused. The evidence was put forward. I haven't heard the state dispute the accuracy of the evidence given. They're not alleging that he most likely holds secretly copious resources. If he did, the public defense system never could have been appointed. I mean, we already know that he's indigent, and in this case, his form of indigency simply wasn't part of the record, and I wasn't able to get a hold of it. So
Your position then that if somebody is poor on the date of sentencing, that they should never have to pay restitution during incarceration, that it's
No, not at all.
simply as a matter of law?
no, not at all. In fact, I recently represented another client that was ordered to pay restitution while in prison at a rate of, I think it was 15% of her monthly income once she begins earning it. I think that's a completely fair and reasonable order. That way it's tied to the actual, once she actually earns money, she will be paying a part of it. And that ensures both that the victim gets immediately compensated and that she's not put in the untenable position of not being able to buy soap or shower shoes.
So it sounds like from what you just said, that you sort of answered the question I wanted to ask, but I want to make sure that you wouldn't actually take issue with what I understood the state's position to be when I sort of pressed in on the low dollar amount, that there's some measure of symbolic importance actually of some minimal payment, even while a defendant who's indigent is incarcerated.
Yeah. I
So
think
even if
that's-
it's like $5 or whatever.
I think that if the
You're not,
district court.
I'm
finds-
sorry,
Yeah,
you're not
sorry.
taking an issue with that.
No. Sorry, I didn't mean to interrupt
No,
you.
that's okay. I appreciate the.
Yeah, no, I would agree that certainly there are certain amounts that could be ordered while a person is incarcerated that would be reasonable. I think tying it to the influx of income is a really smart way to do that. And I've seen since the statute changed in 2020 to have the default be that payments are due immediately to a lot more income tied orders. You know, once you get a job in prison, you should pay this much per month. And I think those are a lot more workable, or at least I don't have a good argument that they're not workable so long as there is actual income occurring.
But aren't you proving workability as opposed to unworkability? I mean, you're showing a plan that would clearly be workable. 15% of But but it's your burden to prove that it's unworkable.
Precedent by this court says it's my burden to prove that it's unworkable. And I think that showing that he wasn't able to work and had no money to make payments is evidence that it's unworkable. There's absolutely no way that he could have made these payments absent a job in prison. And as Justice Standridge noted, we can't be sure that he'd get a job in prison. Not everyone gets a job in prison. And based on his work history and what we know about him floating around Topeka and being younger, I think in his early 20s at the time of this, we can't assume that he would get one of the higher paying jobs. I mean, presumably he's going to be limited in the skills that he can perform at.
We really
So
can't assume anything, can we?
I think we can make those inferences based on what evidence is in the record.
Well, isn't that the point? We can't assume anything. So neither can the judge. No one can assume anything. What we have before us is he's broke. You know, it goes back to what I said before. He's broke. And the judge can't say, well, you'll probably get a job when you're in prison. And, you know, you can have your parents or your relatives or your friends give you money so you can make this restitution payment. You know, that's where the speculation comes in and where you've proved this is where I am today. And that I don't have, you know, there's no evidence here to show anything's going to change between today and tomorrow.
Exactly. And isn't that the point of a burden of proof?
Well, I think things have really shifted since Holt. So all of this is relating back to Holt, when the default, of course, was that restitution would be due upon release and determined by the parole board, when there would be another chance for the accused to get up and say, this isn't workable based on my current circumstances today. And so often those restitution orders were upheld despite, you know, sometimes extreme amounts, because a person couldn't prove some future thing that hadn't happened yet. And they would have an opportunity when those circumstances came due to show it again. But in 2020, the legislature amended it and said, the rule is now that restitution is due immediately unless otherwise specified in the court's plan. So this idea that you need to prove some future unworkability doesn't really hold true anymore, because that was based on this idea that, like, you needed to show that it would never be possible, because there would be another opportunity to come before that board and show that it wouldn't be possible upon release. Now, we just have a statute that says the judge has to find compelling circumstances. And we also have imprisonment alone constituting a condition that can make certain repayment plans unworkable, unlike in Holt, because now that money, and in this case specifically, was due to be collected immediately. And I think that the court, the evidence in the record shows that he was going to be immediately incarcerated. I think that could be evidence of his present inability to pay. And he's not arguing he has a future inability to pay. So I don't see why there needs to be more of a burden to put on evidence of that. So I would argue that because of the change in the statute, making restitution due immediately, the type and quality of evidence that need to be presented are not as significant as they were, unless, of course, he was still trying to argue that this 1954-36 was inappropriate upon release. I would also just note quickly that he did answer the court's question. It wasn't his attorney. If you look at volume 5, pages 14 through 16, it's defendant Taylor responding that he doesn't have a job, he doesn't have a car, he doesn't have assets, a bank account with any money in it. And I would also, Justice Deagle, earlier, we were discussing what happens practically under House Bill 2608. The 2020 version of 216604 B2 still permits wage garnishment, as opposing counsel noted, under Chapter 60, Article 7, and under KSA 2169, it's still assigned to the collections agents with the 33% surcharge. And with that, I realize I'm out of time.
Still would be subject to the prejudgment bonding requirements for garnishing something before judgment, correct?
I'm not totally clear on that. I apologize for that. I'm just not a practice at the trial court, so I need to understand it better than I do just by reading the statutes.
Questions? Thank you, Mrs.
Thank you so much for your time.
Thank you to both counsel. We will take this appeal under advisement. I will now call case number 118310 in Ray Holmes.
Mr. Chief Justice, and may it please the court. My name is Curtis Holmes. I am here on the court's request to enter argument on behalf of a petition for reinstatement. We're involved in a proceeding that started over 4 years ago. And we're finally here, hopefully, to resolve something that I think has been in need of some resolution for some time. The relevant court rule in this matter controlling the reinstatement is Rule 232. I have had an opportunity to review that. And I think that I have been able to present at the panel hearing in this matter sufficient evidence to show that I have complied for the most part with Rule 232. I've complied fully with Rule 231 requiring notice. I have required with most of the elements of Rule 232. I would simply indicate that I have been able to use this 4 years as a significant learning process. And to be very honest with you, even though I would request that my license be reinstated, as a practical matter, I will never be returning to the full-time practice of law. I'm currently employed very lucratively as a senior operations administrator with the Federal Express. Oddly enough, the skills associated with that position are tailor-made for an attorney. I am at a desk, I use a computer, I am using legal applications that I never was even aware of as an attorney. My job within the corporate sphere is correcting mistakes made by any number of individuals, most of whom are in the corporation itself, in order to serve the benefit of my customers. And that's something that has, I think, to a large extent, reintroduced something that I believe that I had understood significantly at the time that I entered the legal profession.
When did you make the determination that you're not going to enter the practice of law? Because part of the concern of the hearing panel was that you made representations. Hey, my suspension is going to be up pretty soon. I'll be returning and I might be able to help you. But that was some of the conclusion. So when did you make that determination?
Two significant things have changed.
Okay.
One is at the time that I was doing that, I was working on a part-time basis in a completely different job than I am doing now. For the last 2 years, I have moved into the administrative field. Number one, it's much closer to the law practice that I had had than simply working as a package handler, which is what everybody is required to do when they start working for Federal Express. So I have essentially gone from this point to this point in the corporate sphere. Secondly, I am financially remunerated about as well as I was as an attorney. In fact, to an extent better than many years. I have no reason to return to a full-time legal profession, given the fact that I am in a new job that pays very well, that I am very happy with. And as a third thing, and I want to make this very clear, and it's nothing negative about the profession of law, but it's something that frankly was noticed by my wife. And that is, when I go to work, even though my hours are very odd because I typically go in about 1 o'clock in the morning, I don't come home with my work. My work is completed. I'm done. And she has told me on a number of occasions, boy, you're sure a lot happier than when you were working full-time as an attorney. That being said, there are things that I would still like to accomplish.
So can I ask, and I'm interrupting and I'm sorry, but I
No,
want to, I
fine.
want to get right to what I take to be the substantive question here. Which are the 3 informal admonitions that you received while you were on your period of suspension?
Go ahead.
And would you agree that those 3 were the 3 main things at issue
As far as,
in the reinstatement hearing?
I don't know that those, I don't know that I would agree with that. I think that they did come up. I would also argue that they were directly related to the underlying suspension.
So let me ask you about those 3. And I'll just want to recite the facts real quick. So I know we agree on those. The first was this witness who hadn't been paid, who filed a complaint, but then quickly got paid.
Right.
And then you accepted an informal admonition.
Right.
And then there was the file that you were unable to return based on a change of address. And there was another complaint filed, but then when the address was found, the file was returned and you accepted an informal admonition. Is that
Right.
correct?
In fact, it was not just, it wasn't the file. It was actually the balance of a retainer.
Oh, it was
there
money.
So there was some money.
Okay.
And I had sent a check to the only address I had for this person, and it.
But
it was-
otherwise
it
I
was
have the
returned.
facts, right? Like as soon as.
Oh, yeah, as soon as I found out where she was, it was automatic, it was immediately.
And then the third one, the third informal admonition came when it was alleged that you were practicing, you had unauthorized practice of law by the conversation Justice Rosen mentioned, where you told the spouse of a former client, hey, I'm suspended, but when I come back, which I think might be within this year period or whatever, I might be able to help you. Is that correct?
That essentially.
Okay, so
Right.
and you heard me emphasize practicality, I think earlier this morning. Practically speaking, why did you acquiesce in each of these informal admonitions?
Because I believe that there was some underlying cause. I didn't believe that it was particularly egregious, but I believe that there was some negligence on my part.
Did you think there were rule violations? And I know I'm asking you a hard question because now you don't want to contradict yourself, but.
I believe that they're certainly in a gray area. I think that you could make an argument either way. And to be very honest with you, I acquiesce to those to a large extent to provide or to avoid
A prolonged
going
process of
through,
litigation.
yeah, a long, prolonged,
Is it fair to,
psychologically traumatizing ordeal,
it was easier not to fight it?
basically speaking.
And did you have any notion when you decided not to fight these, that they would be used to deny a petition for reinstatement?
I knew that they would come in as a factor. And I believe that it was certainly a possibility. But I'd been through a couple of informal admonitions previously, and I had not seen any impact from those previously. In any event, there is one area that I freely admit I need to catch up on, and I think I've done pretty much everything else, and that is that there are continuing legal education credits that I need to take care of. Unfortunately, I have had some work issues. I mean, simply volume of work that has interfered with that. I've also had some health issues that have impaired that.
If we grant your petition for reinstatement, when do you think it would be reasonable to think that you would be caught up on your hours?
I believe that we're coming up on the worst time of my work during the year, which is the holidays. As we get towards the holidays, my hours go from close to 50 hours a week, and then they suddenly jump to over 60 hours a week. That particular time would be very difficult for me to do it. However, there is traditionally a tremendous drop in the work schedule once the holidays are over. I would anticipate over a period of 2 to 3 months following January 1st, I would be able to take up the time to get the rest of those done. And as a practical matter, I want the court to be aware, I enjoy them. I've taught continuing legal education courses on a number of occasions. I taught in areas of both bankruptcy and on civil rights. And I have always enjoyed the continuing legal education courses. It's simply, I need to have the time available to sit down and take them. I would prefer to actually take them in a setting with fellow attorneys. But I would believe that within 90 days after the first of the year, I would be able to have those come. But I be very honest with you, I know what my schedule's like up until then, and it would be difficult. Only thing I would add is that, and I think that I stated it in the hearing or the panel hearing in this matter, and that is that again, this has been a tremendous learning experience. There's a natural inclination in me to do what is fair. And what I did that got me in trouble was following that inclination in violation of the rules. I do not apologize for wanting to do what was fair, but I have realized that I have to be in compliance. I've got to be strictly in compliance because all the good intentions in the world don't make up for not actually following the rules. And I've also learned two things that, I mean, shoot, you learn in kindergarten through this. And one is life isn't fair and 2 wrongs don't make a right. And if there's anything that I would add, I may make a number of mistakes. I have made a number of mistakes. I very seldom, if ever, make the same mistake twice. So there is a learning process I go through and have gone through. And unless there are any other questions, I appreciate the board. Rest.
Art?
Madam Chief Justice, members of the court, I am here and available for any questions. I would note that this was a case that Mr. Holmes sought reinstatement in this case. Reinstatement is set forth by our attorney discipline rules. It's in Supreme Court Rule 232. These rules and the procedure set forth in these rules were followed throughout this case. I would note that once Mr. Holmes submitted his petition for reinstatement and the disciplinary administrator's office was ordered by the court to conduct an investigation, one of the items we do is send out a questionnaire for the respondent to fill out. As part of the reinstatement process, this was filled out. In investigating Mr. Holmes and his ability to be ready to be reinstated and reinstated, there were those 3 docketed complaints that were mentioned. Those were fully investigated. The course of that process, as the court is aware, is that once a complaint is docketed, it is assigned to an investigator, it is investigated. The investigator submits a report. A disciplinary administrator reviews it, submits a report to the review committee, which is a 3-person panel that reviews all all docketed complaints that come in through the disciplinary administrator's office. The review panel found with these 3 docketed complaints that probable cause did exist for violations of the rules of attorney discipline. And
Can I jump in and ask
Please
some
do.
questions about those 3? If those 3 informal admonitions were just magically out of this case, would the position of your office be different on reinstatement? I mean, another way to say it is there anything else that's keeping reinstatement from occurring other than those 3 complaints?
I cannot speak specifically for the hearing panel that made the
That
recommendation.
was going to be my follow-up question. At first, I was going to ask about your office's position, and then I was going to ask you to sort of speculate about whether you thought the hearing panel found anything.
Sure, and Justice Stiegel, quite honestly, what we looked at and we considered were those reinstatement factors, those 9 reinstatement factors set forth in Rule 232. And it was the disciplinary administrator's office's position that these factors weren't met.
The reason,
Prior to the hearing, the parties were given the opportunity to submit exhibits, submit witness lists. Mr. Holmes submitted 4 exhibits. And then at the hearing, he only called himself. He was the only witness of which he presented. And in looking at the 9 factors, it would be my office's position he didn't meet those. Particularly, he was not conscious of the wrongful nature of his misconduct and the disrepute that the misconduct brought on the profession. His conduct since the court imposed the discipline, particularly concerning, was the finding and the acceptance that he practiced law.
okay, so let's talk about that a little bit,
Sure.
because that is what I want to talk about,
Sure.
is the finding and acceptance. Because as I read this, I'll just tell you, it's probably obvious from my questions. It strikes me that this case turns on those 3 informal admonitions. And I'll, again, sort of cutting to the chase, they strike me as incredibly thin as rule violations. But you educate me on that process. I mean, the complaint gets filed, so your office has to do what it's supposed to do, which you did, which is investigate and so on and so forth, and then present that to the respondent. And you know, how does this come about? The respondent just, it's easier not to fight this, so you sort of acquiesce so that you can get an informal admonition. That more or less a correct summary.
I cannot speak for why anybody would agree to an informal admonition versus asking that a disciplinary hearing be held, and that the office of the disciplinary administrator be held to their burden of proof that misconduct did occur and rules violations did occur. I can't speculate why Mr. Holmes agreed or did not to this finding and this resolution. The way it procedurally, the way it works is the review committee directs the disciplinary administrator's office of what actions it approves. And in these instances, it was authorizing an informal admonition or
Then the disciplinary
institute
office
informal
turns
charges.
around and uses that admission, which is it follows a good incentive. I mean, we want to incentivize settling these cases if possible. That's what an informal admonition really is. It's a agreed settlement essentially. And then that admission gets used pretty harshly, I would say, against the respondent to keep him out of being readmitted after he serves his 1-year suspension. I want to give you an opportunity to, I mean, I'm coloring the facts in a way that's not especially favorable to the disciplinary administrator's office. Is what's wrong with how I described that?
I think it's fair to say that attorneys are held to a higher standard of ethics and conduct than somebody who doesn't have a law license. While an attorney is suspended or disbarred, oftentimes, or on disability status, oftentimes docketed complaints or complaints are not necessarily dealt with or docketed because they are not practicing law. They're suspended, they're disbarred. In making the determination as to whether an individual has met the factors of reinstatement, I would submit that it's absolutely proper to look and see, are there unresolved complaints that weren't dealt with before the suspension occurred or that were submitted to the Office of the Disciplinary Administrator after the suspension occurred that need to be addressed and need to be taken into account.
So the lesson here is that attorneys who face a reinstatement hearing are incentivized to fight every little complaint that comes in to the nth degree, because if they don't, it's going to be used against them when it comes to reinstatement.
I would note that if the disciplinary administrator's office docketed every little complaint that came into our office, we would be drowning in work. I would say approximately 1 in 10 complaints actually get docketed. And then there's several steps of review. Once the complaint is docketed, the attorney investigator, special investigator assigned makes a recommendation if a rules violation has occurred. That's then reviewed by a deputy disciplinary administrator or disciplinary administrator who then makes the recommendation to the review committee, who's made up of attorneys from the Board of Discipline. The attorneys that review all the complaints that are docketed and then submitted through these reports, it's the same 3 attorneys that review every single investigation that has come so as to have consistency and to avoid every little complaint being filed, but instead focus on the ones where there is evidence, at least to the level of probable cause.
But that leads to, I guess, really my last question. I know I've asked a lot of questions. I'm sorry for that. Substantively, what's your best argument that the facts, which I think are pretty undisputed, established an unauthorized practice of law?
I want to touch first on your comment that they're essentially undisputed, Justice Stiegel. I would note that the attorney discipline case law has long held that the Supreme Court gives the final hearing report the same level of deference as a special verdict by a jury or a district court finding. And if there is conflicting testimony or that sort of thing, that the Supreme Court recognizes that the panel, as the trier of fact, had the opportunity to observe the witness, evaluate credibility and demeanor. And as far as reweighing that, that's something that doesn't happen.
Yeah, I don't want to reweigh facts. My understanding is that there's really no dispute that the conversation at issue was between the respondent and the spouse of a former client. And the spouse said, hey, this person, I think, if I remember correctly, is getting out of jail soon. What can you do? And that the respondents said, I'm suspended. I can't do anything. but I can let you know when I get off suspension. And that's, would you agree that those are the facts?
I think essentially those are the facts.
So then
in this
my
case.
question is,
Sure.
I just want to hear your best argument as to why those facts constitute the unauthorized practice of law.
The respondent in this case made affirmations or statements to a potential client who was incarcerated. I'll be able to handle your case. I'll be able to handle I'm suspended right now. It should be done pretty quickly. I should be unsuspended. And I'm paraphrasing right now. But essentially he said, I should be unsuspended before your spouse gets out of jail.
Let me
and
ask a
you'll be able to
hypothetical.
handle
I know I
this."
said this is my last question. A student at KU Law School is a 3L. The student's grandmother says, "Oh, I'm so proud of you. Can you write my will?" And the student says, "Well, you know, I haven't taken the bar yet and I haven't been sworn in, but I expect that will happen this summer. And then I'd love to write your will, Grandma." Has that person practiced law without authorization?
That person puts the caveat before it in your hypothetical of, I can't do it, but I expect to pass the bar and then I will be able to do it.
And what's different about that from this situation?
Let me pull up the exact language that was used, Justice. I would point out in this instance, when once a reinstatement hearing has been, or request has been denied, there is a procedure where the respondent can file exceptions, much like anything. Those exceptions weren't filed, so the hearing report is admitted. And I would also note Rule 232 notes that a finding of notes that the court may request oral argument or written briefs on the matter. And in this instance, oral argument was recommended or requested. And coming into this, it was just being familiar with the record and being here and being available for questions such as yours.
And I appreciate that. I've given you a lot of questions.
Sure. And I would note that the hearing committee also spoke with Mr. Holmes about this, and you can see this on page 79 of the transcript of the reinstatement hearing that was held before the disciplinary administrator's office. Mr. Holmes noted in this hearing, and in his words, his potential client was of the belief that Mr. Holmes was going to be able to represent him. And he notes, it reflected badly on me in the situation because I think he relied on me to be reinstated and he was hoping I would be. And he says that, any competent attorney couldn't have handled, but we deal in trust. And when you can't follow through with something that you promised, you lose trust. And that was wrong on my part. It was foolish on my part. And whether I intended it or not, it created a problem. And I think that goes to show, and perhaps I'm not standing here speculating as much, but Mr. Holmes is also of the shared belief that the statements he made, the affirmations or expectations he set forth with this potential client, this individual, was, I'm going to be able to represent you, and this person relied on him. And we have an attorney who's standing before the court asking to be reinstated today. And the reason he was initially suspended was because of saying things that were untrue. He made several false statements in the course of his disciplinary proceeding. And I would note in his final hearing report on the initial suspension that then the Supreme Court adopted in 307 CAN 871 in the matter of Holmes, paragraph 88 of that final hearing report notes, an attorney's word must be his bond. When an attorney cannot be trusted to be honest and complete in his recitation of facts, the attorney should no longer be entrusted with the practice of law.
I'm sorry, I didn't hear a promise, though.
Yeah,
I heard harm that may have resulted from reliance. Something somebody thought was going to happen, but I didn't promised he would represent him.
Let me, to that point, I want to clarify, having read the transcript, just to put this in context, tell me if I get something wrong here, that what happened was he represented this individual, and this individual went through all the preliminary stuff in Johnson County and Leavenworth County on criminal charges, but he was detained in Missouri for some criminal charges there. And so he's in jail. And the big mess up here, according to, Mr. Holmes, was that when he had no written agreement with this individual. And so the whole thing was, when he was released from detention in Missouri, he still needed to be sentenced. And so the money he gave to Mr. Holmes, and please tell me if I'm wrong with the facts, the money he gave Mr. Holmes, he thought, hey, I paid for representation. In other words, a flat fee for both of these cases in Leavenworth and Johnson. And so I'm waiting for him to get unsuspended because I don't want to go pay a new lawyer. And so that's, but Mr. Holmes, not knowing that that's what he was thinking, because he later says, I never would have done a flat fee. So that's where the complaint came out of, when it comes out that no, even if I did get unsuspended or released from suspension, I'd charge you anyway. That was the impetus for the complaint in this case. Is that correct? Because this is the client that, it wasn't necessary, it was to extent reliance, but that's the way that I understood it. And so even Mr. Holmes, who really fell on the sword here during this testimony and said, that was my bad. I didn't have a written agreement with this guy. And so he took a CLE class. It was ethics. And, and he testifies and says, I learned right then and there, this is while he's suspended, I learned right then and there, I got to have a written agreement with my client, because I didn't have a written fee agreement with my client. So contextualizing all this, that's what happened. Is that correct or not?
Yes.
Okay.
That is correct, in that he continued to client through the spouse while he was suspended, which is something that you specifically out of law license is clients about the status of cases while you, and he's communicating with his client through the spouse as far as hopes and desires and things that he hopes to do, and expectations that I should be able to handle this. I should be unsuspended pretty quickly in this case. And then that in fact did not happen.
But what happened, I don't know from reading this, but at some point what happens is, and I probably do have the complaint. I don't know whether I have a complaint or not. Probably in the record, I do have the complaint, but the complaint is more about the flat fee thing, right? Than about, wasn't that the complaint, but then it was, investigated as unauthorized practice of law. Cause I think when it came out that I'm not going to do this for free, then it's like, so he, I'm going to get unsuspended. I'm going to get unsuspended. So it wasn't like, oh, I might not get unsuspended. It's like, oh, you think that I'm gonna be doing this for free? No. Right or
But-
not?
But again, it's the articulation of, we're discussing what I'm going to do as your attorney and how I'm going to handle this. And we're going to talk about the fee agreement and what's going on. And all that discussion is ultimately what results in that unauthorized practice of law. And, you know, in this case, we're looking at, yes, 1.2 scope of representation, and, you know, 1.4 communication was adequate communication. And because there weren't these two other things, it also results in that unauthorized practice of law finding is, I think, how we would get there. I would just ask members of the court that this is a case where once the final hearing panel submitted their recommendation and finding that Mr. Holmes did not meet his burden in proving the 9 factors set forth for reinstatement in this case. And in looking at that final hearing report, it wasn't just, the panel didn't just look at, oh, you had IAs, so you accepted IAs, so we're not going to reinstate you. You know, they looked and they found that Mr. Holmes did not establish that he was his consciousness of the wrongful nature of his misconduct and the disrepute brought to the profession. He did not meet that. That the serious of the serious does not preclude reinstatement. That his conduct since the court imposed the discipline did not meet that. His compliance with Supreme Court orders, he did not meet his burden in proving that factor, that he did not engage in the unauthorized practice of law, that he did not meet that factor. The panel looked at the totality of everything. Mr. Holmes was afforded due process. He was given the ability to present argument, to present exhibits, to present letters of support. He was given ample opportunity and time to get to the place where he could prove these factors. And when he came to the reinstatement hearing and called himself as his only witness, submitted 4 exhibits, and his lengthy testimony under oath to the hearing panel, both where he was given the ability to and the opportunity to present everything that he wanted to present testimonially and evidence-wise. He was subject to cross-examination by the Office of the Disciplinary Administrator. And then if you look at the transcripts, or you look at the transcript of the reinstatement hearing, the 3-member panel of the reinstatement hearing also engaged in some extensive back and forth and questioning of Mr. Holmes under oath. This was a time where they had opportunity to evaluate and make that determination if he met his burden of proof. They found he didn't and issued the final hearing report. And not only did they find that he didn't, Mr. Holmes had the ability to take exception to this, to say, I should be reinstated. I object. I don't agree with this finding of fact. I don't agree with this conclusion of law. He was given 21 days after the final hearing report was issued to file these exceptions. He did not file exceptions. And as such, he essentially has agreed to the findings, and not essentially, he has agreed to the findings of fact and conclusions of law. So we're here today where all the parties involved, the disciplinary administrator's office, the hearing panel, and the petitioner agree with all the findings of fact and conclusions of law.
Which rule is it that says if you don't file exceptions to a reinstatement panel hearing report? Can you cite can you tell me which rule that is so I can look at it?
So Rule 232 is your reinstatement following suspension or disbarment. In looking at Rule 232 under subsection G4, if reinstatement is not recommended, the petitioner may file with the Supreme Court an exception to a finding of fact or a conclusion of law no longer than 21 days after service of a copy of the reinstatement final hearing report. And in this instance, the disciplinary administrator's office waited that 21 days to give Mr. Holmes that ability to, file exceptions, and this did not happen. And it was once that was done that it was submitted.
And do you know, and this, I'm asking because I don't know the answer to this question.
Sure.
Does that mirror identically the rule that talks about filing exceptions to a hearing panel report on a disciplinary complaint? In other words, the part about if you don't file, they're deemed accepted. Is that different or the same?
Well, I want to clarify in Rule 232, there's nothing in that rule that specifically says if you do not file, they are deemed accepted.
But there is that provision in the I'll call it the regular exceptions to a hearing panel report. It expressly says that in that rule, if I remember correctly. Do you? And I'm going to be embarrassed if I'm wrong on
Sure.
that because I should know the rules.
I certainly don't. For memory, Justice.
Well, it would be perfectly
but I
fine to
can-
question it.
I have it here. It's in subsection G. That rule, it says the disciplinary administrator and the respondent may contest the recommendation. I'm sorry, I had it here and I just lost it. The respondent. If the respondent fails to timely file an exception, the findings of fact and conclusions of law in the final hearing report.
And that's in the final hearing report rule, correct?
Thank you, Chief, for actually looking at the rule. Does that make any difference? That distinction between these two rules? Difference?
I don't think it does because the rule that we are talking about here that Chief Justice Lukert quoted from is Rule 226. And that rule is I apologize. 228G is the procedure before the Supreme Court. And what that rule talks about and what I'm looking for in this, because initially what I was thinking, when you look at Rule 226, which is the final hearing report rule, that rule initially talks about following a hearing on a formal complaint. And because a reinstatement petition is just a little bit different animal than a formal hearing complaint, I wanted to go and look at 228 and see if that references a formal complaint versus just a matter or action in the final hearing report. And I think that because it's distinguishable, from that, and it just refers to the final hearing report and submitting the exceptions, I don't necessarily think that that makes a difference in determining whether the findings of fact and conclusions of law are all deemed admitted or not if exceptions aren't filed. I think that it would be meet and right and appropriate to refer back to that Rule 228 to determine that. And if there are no other questions, thank you very much. I appreciate it.
Reserve 5 minutes.
Madam Chief Justice, may it please the court. I would only like to touch on a couple of things that were brought out by the disciplinary administrator's office this morning. One is an assertion that somehow I have failed to accept seriousness of the underlying offense, or that I failed to appreciate that. There was a statement provided in my testimony by the disciplinary counsel herself that I believe belies that. That is, and I had made it in a number of occasions of what this has done to my clients, that I had lost trust. I had also lost trust with the profession. I had made it clear that I believed that the underlying act for which I received the suspension was based upon a good intention, in that I saw a horrible injustice being perpetrated. And I acted right after I found out that I had an administrative suspension. That was the mistake, and I recognize that. But I believe that it is incorrect to conflate that sense of wanting to bring about a just result with a failure to appreciate the wrongfulness of the conduct. Do both. Say, well, I had a good intention. Boy, was I wrong. And I made that, I believe, clear in the panel. Secondly, and I don't mean to disparage counsel in this matter, but there's a lot she got wrong. During the course of the hearing, statements were made about things that I had allegedly done I didn't even recognize. There were statements made about where I had practiced, what state, that was wrong. I believe that there have been misrepresentations made about me and my character throughout this proceeding that unfortunately, I believe reflected on the panel. I also believe that with respect to whether or not the findings of fact are absolutely binding is distinguishable from Rule 228 in the sense that we're dealing in the first place in this situation with a hearing panel, and it's my understanding that this body is the final arbiter, not the hearing panel. That you are free to look at the evidence that was provided, not to counteract, or not to ignore that evidence, not to reject it, but to certainly countenance in the context in which it was provided, which may not always agree with what the hearing panel says. And I think for that reason, that's very different from Rule 228, which makes it explicitly clear than the context of a hearing before the Supreme Court. Any exceptions that are not made to the Supreme Court are deemed admitted.
Mr. Holmes, to that end, and I don't know if you're done, whether you just had to.
No, go ahead.
Okay. Of what was presented in the transcript. I'm kind of late in the transcript, page 97. One of the hearing panel members said, when this hearing started with your original testimony, you said something about how you didn't particularly trust lawyers. And you said yes. And it says, do you have a network of colleagues in the legal profession? And you immediately say, no, I wish I did. but I've had so many bad experiences with attorneys that it's difficult for me to trust other attorneys. And then you basically go on to reiterate that you just don't, let me tell you, I wish I had an attorney that I could rely on or, oh, who do you call when you need help? What's your support system? And you did mention one person, but you can't find him because he's retired. And, but is that still the case now? And
Do I have a distrust for attorneys?
distrust, and do you have a colleague that you could find support in?
I
Because if you
believe
do,
I could find a colleague. And I believe that I had mentioned in the context or in the course of the preceding incidents that have taken
right,
place,
I read that.
that, I mean, I got burned right from the start. My very first boss went to prison. And I've seen situations with attorneys who, in my mind, have done the most reprehensible thing. And yet were patted on the head for being really clever. And yet what they amounted to be doing is essentially what I believe is legal arson.
I guess my question
I think I
is-
carry a little bit of PTSD because of
Right.
that.
But my question more is, I think it's great about the CLEs, but some of the things, decision-making, or even while you're suspended, the incidents that happened while you were suspended, I mean, can you practice law in a vacuum without any legal colleagues?
Not very well.
And I know
What
also-
you can do in a
Yeah.
vacuum.
There were you didn't submit, you talked about the fact that you had trouble finding any lawyers at all to write a letter of recommendation for your reinstatement.
I contacted close to a dozen. All right, let me rephrase it. I endeavored to contact close to a dozen. I was able to contact a few. And I was either told in so many words, I like you, I wish you the best of luck, but I really don't want to get involved. Or just no call back, or I absolutely could not get a hold of them. Can I find somebody? Probably. Do I have a close-knit group of attorneys that I associate with on a regular basis? Not really. Do I have a good, solid base of support? Absolutely.
I read that too.
Absolutely. My family, my coworkers, as a solo practitioner, which is what I was for most of my practice, you don't always get to be a team player. And that's something that I have rectified in my current position. I work with a number of individuals doing what amount essentially the same thing. We all kind of have our different specialties. But I have to work with these people, and I've learned to work very well. I can work in a team setting, and I enjoy that. I have been burned by attorneys. I've been burned by judges. I learned a long time ago that for every Antonin Scalia out there, there's a Roland Freisler in the wings. And so it's, and no disrespect to this body, but it happens. And it's something that sits with you.
Very much.
But yeah, I think I could find something.
Thank you.
Thank you.
Thank you to both counsel. We'll take this under advisement. Court is now adjourned.